Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I'm going to be talking about some changes that are going to happen to tax legislation where organisations are working with contractors or consultants and the like. The IR35 legislation came in 2003. It's actually the income tax legislation that it sits within, and essentially what that legislation does is import a hypothetical contract. So what we might have in reality is our individual person who's supplying their services. They may have chosen to supply their services through a personal service company. So Joe Bloggs might set up Joe Bloggs Limited. One of the reasons Joe Bloggs might do that is to provide a more favourable tax regime for Joe Bloggs. So Joe Bloggs might pay themselves a low salary, and minimal national insurance implications will apply and tax. And then they will take the majority of their earnings out of Joe Bloggs Limited, their personal service company, through dividends in order to make it more tax efficient for them than perhaps being an employee in the traditional sense. We may also have an agency in the picture. So we have our individual, we have our personal service company. We may then have an agency that the end user or the organisation who are buying in the services of the contractor might use to save themselves having to do certain things. They may not be there. And then at the end, we're going to have that end user client. In the tax legislation, they're typically called the fee payer because they're the ones ultimately procuring the services. And what happens in IR35 is that a contract is hypothetically deemed between our individual and the end user. And when looking at that hypothetical contract, the personal service company that sits in the middle is required to make an assessment and say, is it really an employment relationship? So has the end user got control over that person, etc. And if it is the case that it looks and smells like an employment relationship as opposed to the person being genuinely self-employed in their own account, then that personal service company is responsible for deducting tax from the fees that they're paid. Now, the problem with that is that it's been quite difficult for HMRC to enforce. They've had to take case-by-case approaches against personal service companies. They've had different levels of success in doing that. It's estimated that over £1 billion a year is being lost to the Treasury through non-compliance with IR35, and a lot of contractors currently pay membership to organisations like the Professional Contractors Association, which will charge them a membership fee for in effect acting like a bit like a trade union and representing their interests, so that if they are challenged, they've got an insurance policy that will pay their legal fees in having to challenge HMRC through the tax tribunals. In 2017, it was changed in the public sector so that instead of that personal service company being the one having to make the assessment, the burden shifted to the end user, with the effect that a lot of public sector organisations, because it can be quite complicated, because it might be easier to do it this way, have just blanket deemed that those that they're contracting with will deduct the tax from the payments that are being made. And of course, revenue has flowed into the coffers. So the decision has been made to roll this out now to the private sector. So all organisations need to start thinking about what they are doing. The first thing to say is it's not the whole of the private sector that's going to be affected. There are some important exemptions, and it's the definition from the Companies Act, section 382, of small employer that is used in this case. And it's quite an unusual definition in that it may not sound like a small company to you. If you have less than 50 employees, if your turnover is less than 10.2 million, if your balance sheet is less than 5.1 million, then you're not going to be affected. If two of those three apply to you, then you will be within the exemption. So there will be organisations that aren't caught by this. For those larger organisations with more employees, with a higher turnover and balance sheet, you are going to need to start thinking about how this might affect you from the 6th of April 2020. So what are you going to need to do? Well, the first thing you need to do is work out who you are currently contracting with. Who do you bring in to provide their services, maybe on an ad hoc basis, maybe on a more regular basis? What terms have you got in place with those people? Who are the people that you're contracting with? And are they genuinely in business on their own account with lots of customers? So, for example, if you brought me in to do some training for you, obviously I do genuinely run a business on my own account and have got hundreds and hundreds of clients, and there is no way that I would be deemed as being a potential employee of yours. However, there might be people that you work with more closely where you are the only organisation that they are doing work for, and you might have quite high levels of control over what they do, and they might start to look a bit more like an employee. Once we've decided who we've got and what terms we've got in place, then there are a number of other actions that might follow. One might be standardising the terms. If we've got a whole patchwork of different contracts in place, then we may need to look at standardising the terms that we've got. We may need to look at documenting the relationships that we've got to make sure that the documents reflect the actuality of the arrangements. So where we're clear we have got somebody who's genuinely self-employed, we need to emphasise that fact, and we need to gather together the evidence that we've got that tells us that they are genuinely self-employed, so that we can explain our decision tree, if you like, in respect of that person. So that might be gathering evidence of the fact that they provide a substitute, or that they've got other clients, or that we don't exercise control over that person. We might think about putting in place an agency into that chain of contracts that we talked about, where we want to make perhaps life simpler for ourselves and get them to deduct the tax for us. Doesn't take a responsibility away entirely. We're still going to have to go through the assessment side of IR35, but there are some things that could be done there. And we might have to start communicating with those people that we currently work with. We might have contractors that don't appreciate that this is coming. We might have contractors who aren't going to be happy that there's going to be a change to the way in which they're paid. They may want to renegotiate their rates, etc. So there's going to be a whole piece around that we need to start thinking about. The legislation itself has not yet been published, as is often the way, and we are promised reform to HMRC's tool for going online and checking who's who, but I imagine it's likely to be tweaks rather than wholesale changes to what is there in place. So you might want to start looking at what is in place and how that would apply to your circumstances, to start thinking about preparing for April of next year. If you do have any questions, it's adenton@refreshinglawltd.co.uk. Thank you very much.